Good afternoon. It is my pleasure to welcome you today to the Society's virtual platform for a screening of our new documentary on Marbury versus Madison. I am Jim Duff, the Executive Director of the Supreme Court Historical Society. The Society is busy expanding our educational outreach and our civics educational offerings, and this is just a recent example. There will be more to follow. I believe you will learn much from this documentary, and for our teachers in the audience, I believe you'll have much to share with your students. Our panelists today are two expert resources within the Society who are well equipped to share these materials with you. Professor Timothy Eubner is the chair of the Society's Board of Editors and is a member of our Publications Committee. He serves as the Irma O. Sternberg Professor of History at Rhodes College and is the author of a number of books including Liberty and Union, The Civil War Era of Constitutionalism, and The Taney Court, Justice, Rulings, and Legacy. Claire Cushman is the Society's Director of Publications. She is the author and editor of many of her favorite Society works and books, including The Delightful Table for Nine and Court Watchers. Today, Claire and Tim will share why the Society has produced this important new documentary on Marbury versus Madison, and then we'll screen it for you. They will be taking questions from the audience via the Q&A box in Zoom, and we ask you to please ask as many questions as you can. Claire will also be sharing the classroom resources that the Society has in place to support the documentary. A survey will follow later today for everyone who registered in advance. We ask you to please fill that out. We welcome your feedback, and it helps us improve our materials. With that, the Society's virtual platform is yours, Claire and Tim, and we thank you for sharing your insights with us today.
Thank you, Jim, and welcome everyone to our webinar here today. I'm filling in for Don Ayer, who had originally planned to be part of our session, but I'm happy to be here. Once again, I'm Tim Hubner, and I serve as chair of the Board of Editors of the Society. And it's my pleasure to co-host this with of course, Claire Cushman, a familiar face and name, someone whom all of us know very, very well. We're focusing on here today a new documentary on Marbury versus Madison. And I guess, Claire, the Society has made other documentaries before, but maybe you could talk a little bit about why this documentary has been made and how it fits with the other efforts of the Society over the years.
Thanks, Tim. Hello, everybody. Can everyone see me? Yes? Okay, so originally we wanted to make some materials for high school classroom teachers, and we thought about what we could contribute that hadn't already been done before. And we decided to avoid documentaries about landmark cases because those cases have been treated by other organizations and done very well. And we thought that we should maybe focus more on the interplay between the three branches. We looked at some of the other organizations and realized that there were a few things that were missing because judicial history tends to get sort of siloed. So the first documentary that we made was on FDR and the court packing episode of 1937, which of course has the president asking Congress to increase the size of the Supreme Court. We used a lot of the wonderful illustrations from that era, cartoons especially. And then the next one we did was on the 1876 election. We looked at it a little bit differently than it's usually taught in schools. It's usually about the sort of the dividing line between the promise of Reconstruction and the terrible disappointment of Jim Crow. We looked at it differently. We looked at it as Congress appointing a commission that includes 5 Supreme Court justices to resolve a disputed presidential election. You know, the lawyers for the Democrat and the Republican Party who were contesting the votes in the 3 states argued their cases in the Supreme Court room. So we thought that was an interesting episode in sort of Supreme Court history and separation of powers topics. But for our third topic, to really get to the understanding of this, how the system of checks and balances are set, we wanted to go back to Marbury. Now, of course, do teachers need a new Marbury video? There are a lot out there. We looked at them. Is it an overdone topic? Of course, it's incredibly important. So we were very lucky to have a focus group of teachers at the Third Branches Institute. We showed these teachers clips from several of the existing documentaries that are out there, and solicited their feedback. Most of the videos tend to sort of compress the story behind the case. They use computer generated graphics, and they tend to cut as quickly as they can to the holding of the case and talk about judicial review, which is, of course, perfectly understandable. That's the most important part. There were a lot of interesting approaches. I think the State Bar of Georgia made one where the writ of mandamus is personified as a sort of talking creature named Mandy. So they got points for creativity. But clearly everyone's struggling to make this sort of dry and weighty subject, accessible. How do you make Marbury accessible and understandable? We looked at the Annenberg Center, and they have terrific videos. And oddly, they didn't have one on Marbury. They have a great one on McCulloch versus Maryland, though. So when we talked to the teachers, they didn't seem to be quite satisfied with the offerings. And we asked a whole bunch of questions, including, should we hire a young celebrity to be the narrator to grab students' attention? No, they didn't think that was a good idea. They really wanted us to continue in the fashion that we'd done the previous two documentaries. So sort of tell the story calmly, clearly, slowly, so that the students can really get a feel for the time period, especially through the use of illustrations from that time period. And also let them hear the voices of the characters in the story. So we thought, okay, we can try this. We knew that the teachers wanted us to keep it under 15 minutes, preferably 12. We didn't get to 12. Even 15 was a struggle to condense the story. We divided the story into 12 segments, the way we'd done with the other documentaries. Each segment sort of tells the complete mini story, so the teacher can stop the video, ask questions, offer, additional clarification. But the truth is, as Tim knows, this is a tough story to tell, whether you're teaching it in middle school or law school or to history students. This is hard, and it's tempting to just cut straight to the holding and just go right into judicial review or original jurisdiction questions. The problem with telling the story behind the case is that, at first it seems it's a story about the president packing the court, but then no, it's actually about these justices of the peace who don't even have lifetime appointments and no salary. Then it seems to be about Congress repealing these new positions for these judges, but no, that's resolved in Stewart versus Laird, which is a different case, which, by the way, we do include in our Marbury video. So it really should be Marbury versus Madison with Stewart versus Laird. So then it also seems to be, is the writ of mandamus, compelling Madison to do something? Well, no, then it's really not about that. It's the original jurisdiction and the Judiciary Act of 1789. And then finally, you can just sum up the whole thing and be like, well, it's really just about Marshall seizing this opportunity to establish judicial review. But wait a minute, is that a new concept? I don't know. So once we've gone through all of those twists and turns and we're completely confused, we say, okay, how can we help teachers to teach this topic? And by the way, hats off to everyone who teaches this middle school through wherever. I'm in awe of you all. So what did we do? We wrote the script, we hired a narrator, we gathered all the images, and we quickly realized that 1803 was a tough time for images. There are lots of gorgeous oil portraits of the main characters, the presidents, the justices, Marbury. There's some documents of the case. We got headlines from Democratic, Republican newspapers, Federalist newspapers. We had scenes of Washington, Marbury's house, but there wasn't enough material to match the narration, to match the script. So we kind of scratched our heads and we considered, should we go to computer generated graphics? Should we just do that? What should we do? Too expensive is the short answer. Then we considered adding 3D architectural renderings of the rooms where it happened. There are 2 rooms. One is Committee Room 2 in the Capitol building. You remember that only the north wing of the Capitol had been completed at that time. So the justices had to hold session in a very small, cramped little committee room that they shared with other committees. So, we wanted to show that to very symbolically make the point that the judiciary was the weakest branch. We also had great text descriptions of that room from the architect of the Capitol, what the windows look like, the mantelpiece, the fireplace, all of that. So we thought that would be exciting. Then we have the room where it happened too, which is the Stellies Hotel. And that's where the justices were lodging during the 1803 term. And it's very close, or was very close to the Capitol building, within walking distance. And it was a luxurious hotel. And the justices, we know, deliberated the case there, not in the committee room. The most important thing that happened was obviously that Samuel Chase had an attack of gout and could not walk over to the Capitol. So John Marshall delivers the opinion in the front parlor at Stellies Hotel. And apparently, he spoke for 4 hours. This is a long, long opinion. People heard it was going on and walked over from the Capitol and filled up the front parlor. But there are no images of Stellies Hotel. It burned down. It burned down a few years later, and there's almost no text description. So we thought, okay, we're going to use Gatsby's Tavern in Alexandria, which was same time period, same similarly luxurious hotel. It's been reproduced in the Metropolitan Museum of Art, its main parlor. The whole setting, the windows, the mantelpiece, we thought, great, we'll give this to an architect. We'll get these 3D renderings. This will be exciting. Well, way over our budget, not even close. So next thing we said, all right, let's just look at the 5 key scenes that we need to get for these students to be able to visualize what the story is in this case. So we said, okay, Adams signing the midnight appointments, Marshall as Secretary of State, affixing the Great Seal with the sealing wax to the commissions that don't get delivered. Charles Lee arguing the case in Committee Room 2. Of course, only one side argued. That Jefferson didn't want anyone to respond, so it's not really an argument. It's a one-sided case, so that we wouldn't have a second image for that. Then the justices deliberating in the hotel, Marshall delivering the opinion, and lawmakers crowding in to hear him. So those were the key scenes we wanted. And we were really fortunate because we found this wonderful illustrator named Trevor Irvin, who lives in Atlanta. Actually, when I say we, I really mean Dave Buckout, whose company Inheritage produced this documentary. And he's been a wonderful collaborator to the Society on our previous documentaries and other projects. So this illustrator, we gave him all of these sort of historically accurate descriptions of what the justices look like. Here's a portrait of Bushrod Washington, 7 years earlier, and here's one 4 years later, and his age would have been somewhere in between. He had white hair and this and that. The clothing, the rooms, as I said, we had all the detail. So we give them to Trevor, and he does something magical. He takes the historically accurate details, but he uses color and light, and he makes it modern and exciting, like almost a little bit of a Marvel comic look to it. And he really brought these scenes to life in a way that I think students who are, used to seeing a lot of these sort of action Marvel movies will at least know that we're trying to meet them where they are. So the second thing we did to try to bring this alive, again, with the paucity of images, was to get voice actors to speak some of the thoughts of the main characters in the story. So we have John Jay, we have Adams, Jefferson, and Marshall. And this was to break up the narration. The narration can get very dense, and it also to inject some emotion into it. we really feel that students respond to emotion. It keeps them interested. And so hearing Jefferson speak of his frustration of Adams's, court packing, or hearing Marshall, use emphatically declare that, the judiciary has the right to review. You want to hear the emphaticness in Marshall's tone. So we tried to use as many words verbatim from these characters. Some of the vocabulary they use is just incomprehensible today, but we use some ellipses, but it's pretty close. One quick side note, I just have to give a shout out to the actors who volunteered their time to do those short voiceovers. They were all people that were called in at the last minute, because we had planned to hire living history actors who are people that regularly impersonate Jefferson and Marshall, at school events, and they're in costume, but they were way over our budget as well. So I've now described to you all the problems of Marbury, all the challenges, and what I want to do now is to show you, first of all, the society is so grateful for everybody who worked on, supported financially in any way. Tim reviewed the script, who supported this documentary. And again, I just want to reiterate that this is an effort to tell the story calmly, clearly, completely, under 15 minutes, so that then the teachers can then tease out or drill down on the parts of the story that they want to, mostly the last chapters on the holding, and then take it in whatever direction they want. So after we watch it, we will then look at some lesson plans to accompany it. And so now I'm going to share.
While you're getting that set up, Claire, it's just so interesting to hear about the sort of inside story of the making of a documentary, and how much time and effort and how many folks kind of worked hard to make all this possible. So, as you say, we're so grateful for all the work that has actually gone into this. And it is a rich and interesting story that, obviously needs to be told. We don't want to skip straight to the holding. And it's a virtual who's who of the early national period, if you think about all the characters involved here.
In 1800, Thomas Jefferson was elected the third president of the United States. His inauguration, in March 1801, marked the first time in the short history of the new nation that a political party handed power to its rival. Federalists had held the presidency under John Adams, but Jefferson was a Democratic Republican. The election also changed Congress, as Democratic Republicans won more seats than Federalists. The judicial branch, however, was not subject to elections. So while Adams allowed for the peaceful transfer of executive power, he tried to extend Federalist control of the judiciary. Before leaving office, Adams pushed Congress to pass the Judiciary Act of 1801, which created new circuit courts. This gave Adams the opportunity to pick members of his own party to preside over these courts as lifetime appointees. This would keep Federalist majority control over the third branch of government. Adams' brazen court packing angered Jefferson. His opposition led to a constitutional crisis about the interplay of power among the executive, legislative, and judicial branches. The crisis was resolved by a case brought before the Supreme Court. Here is the story of Marbury versus Madison, the most important legal decision in American history. In December 1800, an ailing Oliver Ellsworth, third Chief Justice of the Supreme Court, resigned. Outgoing President John Adams asked Secretary of State John Marshall to send news of the vacant position to John Jay, who had served as the first Chief Justice. Adams wanted Jay to return and replace Ellsworth. Jay declined.
The Supreme Court is the last resort for delivering justice to the nation. Accordingly, it must have the confidence and respect of the public, not their neglect and indifference. But under the present system, I doubt the court will ever possess any meaningful authority, stature, or power.
Jay was right in that the judicial branch was constitutionally designed to be weaker than the executive and legislative branches. At the time, state courts decided most legal disputes, and the Supreme Court had never struck down a federal law. Not even meriting its own building, it borrowed a cramped committee room in the Capitol to hold court sessions. Secretary of State Marshall was not surprised Jay declined to return. But what Marshall could not know was that in January 1801, his own name would be up for Senate confirmation as the fourth Chief Justice of the Supreme Court. By age 45, Marshall had built an impressive resume. After serving as an aide to George Washington during the Revolutionary War, he established himself as a successful lawyer in Richmond, Virginia. He played an important role in Virginia's Constitutional Convention. Elected to the U.S. House of Representatives, Marshall became an alliance builder in Congress. Witty and likable, he was admired for his sharp legal mind. President Adams appointed him Secretary of State to handle difficult diplomatic missions to Europe. But even Adams could not have known, when he chose Marshall to be Chief Justice, how brilliant he was. Marshall would draw on all his talents to bring his Supreme Court the power and prestige it deserved. Just weeks before Adams transferred the presidency to Jefferson, the Federalists in Congress passed the Judiciary Act of 1801. This act created 6 new circuit courts to handle appeals and serve as intermediaries between local trial courts and the Supreme Court. Adams was thankful to have 16 new judicial seats to fill with judges. His appointees, mostly Federalists, would prevent the incoming Democratic-Republican administration from taking control of the judiciary in addition to the presidency and Congress.
I shall secure the future of the judiciary by blocking Mr. Jefferson from making lifetime appointments of judges.
In his last days in office, Adams submitted his 16 nominations to the Senate, which voted to confirm them. He then stayed up late on the eve of his departure. At his desk in the President's house, Adams formally signed the legal documents appointing the midnight judges. Jefferson, now president, feared such a judicial stronghold would block his own administration's agenda of decentralizing power.
Mr. Adams, midnight appointments are an outrage on decency. He is packing the judiciary with men whose views are to defeat mine. Since the Constitution says it is the role of Congress to organize the judiciary, I will petition lawmakers to cut back its power.
The Democratic-Republican majority complied. In March 1802, the Judiciary Act that had instituted the new court system was repealed, thereby abolishing the seats of Adams' midnight judges. Chief Justice Marshall believed that judges should only be removed by impeachment for wrongdoing, not by politically motivated legislation. But wanting his court to avoid conflict, he complied with the Repeal Act. This meant the justices themselves had to once again take on the extra work of hearing cases in far-flung circuit courts, arduous work they had begrudgingly performed from 1790 to 1801. As well as the 16 federal judges, the Judiciary Act of 1801 gave Adams last-minute authorization to appoint 42 justices of the peace in the District of Columbia, which had just been made the nation's capital. Justices of the peace served 5-year terms and drew no salary. Their job was to resolve minor disputes by leveling small fines. The president's nomination of prominent Washington businessman and leading Federalist William Marbury for one of the positions was rushed to the Senate, where it was hastily confirmed. John Marshall, still acting Secretary of State, affixed the Great Seal of the United States to the appointment document, the commission, 1 day before Adams left office. But in the chaos of a changing administration, Marshall and his harried staff failed to deliver the document to Marbury. They also neglected to deliver commissions to 16 other Justice of the Peace appointees. Would their undelivered commissions, which gave them the legal right to take office, be honored by the incoming administration? Jefferson sought to push back on all of Adams' appointments, so he used inaction on delivering the commissions to block Marbury and the others from their Justice of the Peace positions. Angry, Marbury hired Charles Lee, who had served as Attorney General under Adams, as his lawyer. Lee requested that the Supreme Court compel delivery of the commission to Marbury and 3 other men owed Justice of the Peace jobs who had joined Marbury's lawsuit. He asked the court to issue a writ of mandamus, which is a command from a higher court ordering an inferior government official to fulfill his duties. Chief Justice Marshall issued the writ to James Madison, Jefferson's new Secretary of State, as it was Madison's department's job to deliver the commissions. But as Jefferson's closest advisor, Madison simply ignored it. His refusal to comply with the mandamus led to Marbury's lawsuit being tried in the Supreme Court. That it went there directly, as original jurisdiction, without first being tried in a lower federal court and then being appealed, would become important in how the case was decided. Meanwhile, a viciously partisan debate over the writ of mandamus flared in Congress. Federalist senators argued that the Supreme Court had the power to decide that members of the executive branch acted unconstitutionally by disobeying the writ. The Democratic-Republican senators disagreed. In their view, it was strictly the power of Congress, whose legislators are directly elected by the American people, to place checks on the executive branch. Unelected judges, they protested, had no right to force the executive branch to obey an order of the court. Along those same lines, Congress debated the constitutionality of the Repeal Act, which had taken away the new judgeships. Chief Justice Marshall faced a dilemma.
If I back down and let Mr. Madison ignore my order, I risk having this court exposed as powerless because we have no way of enforcing our decisions. But if I force him to comply, Mr. Jefferson might ask Congress to impeach us.
Was there a way for Marshall to resolve this predicament and assert the independence of the Supreme Court from partisan politics? And how could he proclaim the court's authority without the other 2 branches feeling that their power was threatened and provoking a showdown? As part of its power play over the judiciary, Congress had shut down the Supreme Court by preventing the justices from holding session for 14 months. This was a tactic to delay hearing Marbury's case and a second case, Stewart v. Laird, which questioned the legality of the Repeal Act. Finally, in February 1803, Attorney Charles Lee stood before 4 of the justices. 2 were absent due to illness, in a packed committee room serving as their court, to argue Marbury's case. A skilled lawyer, Lee was an ardent Federalist and an old friend of Marshall's.
Mr. Madison is Secretary of State and thus a public servant. He is not above the law. He must comply with this court's writ of mandamus and reissue the commissions to my clients. They have established the right to the job to which they have been duly appointed.
Lee's closing statement framed things in a larger way. Because justices of the peace were minor judicial officials, he said, the case was more about upholding the independence of the judicial branch. To argue the opposing side, the Jefferson administration would have normally used its Attorney General, Levi Lincoln. But in a challenge of the Supreme Court's authority, Jefferson refused to send a lawyer to represent the government. Over the next 2 weeks, the justices met privately to deliberate the case. How would the court rule? The justices decided the case unanimously. On February 24th, Marshall read the court's opinion. It took him almost 4 hours to read its 10,000 words.
The Senate approved Mr. Marbury's appointment. The President signed the commission, and the Secretary of State sealed it. Mr. Madison thus acted in plain violation of Mr. Marbury's right to his commission. Subsequently, Mr. Madison has not shown cause as to why he should disobey this court's order to reissue the missing commission.
Then, to everyone's surprise, Marshall went on to introduce a new concept not in Lee's arguments. He focused on the Judiciary Act of 1789, enacted by Congress to establish the structure of the federal court system and define its powers. The Chief Justice reasoned that his own court had violated Section 13, the part pertaining to writs of mandamus issued by government officials to courts. He held that it limited the Supreme Court to hearing complaints about this type of writ only on appeal. So instead of going directly to the Supreme Court, Marbury's case ought to have been tried first in a lower federal court. Had he lost there, Marbury could have appealed to the Supreme Court, where the justices would have then had legal grounds to issue the mandamus as an exercise of their appellate jurisdiction. Because this protocol was not followed, the writ of mandamus, which Madison ignored, was deemed invalid. Marbury and the other plaintiffs lost their case. They would not get the jobs promised to them by Adams. Chief Justice John Marshall tactically gave up a small battle over enforcing the mandamus to assert a much greater power. He declared Section 13 of the Judiciary Act was not consistent with the Constitution and was therefore invalid.
The words in the Constitution are a higher form of law, more fundamental and paramount than any act passed by Congress. The Constitution is the supreme law of the land, which means that any law which is inconsistent with it is void.
Who, then, has the authority to interpret the words of the Constitution? Unelected judges or members of Congress chosen by the people?
It is emphatically the province and duty of the judicial department to say what the law is. Judges who apply the rule to particular cases must of necessity explain and interpret that rule.
Giving the judicial branch this interpretational responsibility meant the Supreme Court had the power to decide whether an act of Congress or an order by the executive branch was in violation of the Constitution. The power Marshall was asserting is called judicial review. It was not a new concept. State courts were already allowed to find state laws unconstitutional, and delegates to the Constitutional Convention had spoken explicitly about giving federal courts the same authority. But judicial review was not spelled out in the Constitution. Marshall used the constitutional crisis surrounding the Marbury case to establish the Supreme Court's authority to strike down executive or congressional acts it judged to be unconstitutional. Marshall's masterful decision in Marbury v. Madison managed to expand the High Court's power while diplomatically averting a showdown with Congress. Only a week later, the court again rose above factional party politics when Justice William Patterson issued a short ruling in Stewart v. Laird. The Federalist-dominated Supreme Court voted unanimously not to strike down the Repeal Act. That was the act Democratic Republicans had passed to abolish the circuit court seats former President Adams had worked to fill with the Federalist midnight judges. Although President Jefferson complained about the twistifications in Marshall's logic, the Democratic Republicans accepted the Marbury v. Madison decision. This was because Marshall had chosen to assert judicial review with a case that recognized the power of Congress and limited the court's power. The Supreme Court has since relied on the Marbury precedent to ensure that government acts comply with the Constitution in a variety of pivotal cases affecting the political, economic, and social fabric of the nation.
Okay, so as you can see, we sort of leave it with a lot more to be said about Marbury versus Madison so that the teachers can sort of take it from there. So Tim, do you think, should I start walking through some of the lesson plans?
Sure, I think so. Maybe at this point, if you have lesson plans to share from the website, you could keep sharing your screen as it is and kind of walk us through some of those. And maybe we could spend a few moments on that as we're waiting for questions to sort of come in, and then we can answer some of those questions and talk a little bit about the significance of Marbury. So why don't you go ahead and show us what other resources you have for teachers?
When we were talking with some of the teachers in the focus group, there's definitely a demand for teaching materials for middle school students, which kind of surprised us. And obviously this documentary is pretty sophisticated, but I do feel that middle school teachers can, extract parts of it that would be appropriate for middle school students. Certainly just using the illustrations or some of the voice narration. So here we are at landmarkcases.org. Street Law, who's the society's partner that we help fund, has made these lesson plans, and we really think there are actually a lot of great lesson plans out there about on Marbury, but this is the one that we're really recommending to teachers. So I'm going to just give you a quick sort of overview of it. The most important thing is that you can see there's a section for students that has all the PDF materials that you can just download and give directly to the students that are perfectly formatted for the students to answer the questions, fill in the blanks, whatever is required of them. So that's very convenient for teachers. And then I'm going to go down to the bottom where Landmark Cases has also helpfully given planning time and activities for teachers with if you have 1 day, if you have 2 days, if you have 4 days, how great would that be? So I'm going to start with the if you have 1 day and look at, let's look at the first thing they recommend, which is the case background. Here we go. Here we go now. So I'm going to just quickly click on the background reading. This is for the middle school. You can see that they give an overview of the case and then questions to consider. I'm actually showing you the one that has the answers for the teachers on it. Clear, straightforward questions, very helpful. And then I'm going to go back and show you for advanced high school. It's actually pretty similar, the same questions, but then they do add Article 3, Section 2 to talk about original jurisdiction, which I think is a little too sophisticated for the middle school students. And then there's also an advanced high school, which I'm not going to show you today. If you want to look at that. Then what Landmark Cases suggests is that then you go to the who should decide activity. And here we go. I'm going to again show it to you with the answers. So here you have, this is more the theoretical component to judicial review. I'm not going to questions and certainly not all the answers, but I thought maybe if I just sort of scroll over it slowly, you can kind of get a sense of what this activity is. It's really more of a conceptual, theoretical, having the students really think about these issues in a more fundamental way, not just about the case. And then once that is completed, the next thing that Landmark Cases suggest is to go into their classifying arguments activity. And that's here. So this is a very clever way to, I think, engage the students. they have the argument, they have a short argument snippet, and then if the argument supports the petitioner, the student answers Marbury. If it supports the respondent, they answer Madison. And this is a great exercise because you can work in groups and then really have a frank discussion of do you think which side argued the case or had the better arguments, I should say. Only one side actually argued the case, which is always a problem teaching this. But and again, it also contains the facts, and then it has great little snippets from Section 2 and the part of the Judiciary Act of 1789 pertaining to writs of mandamus. So that's a nice self-contained unit. And then if you have 2 days, we get into things that are a little bit more sophisticated. I'm just going to go to the cartoon analysis activity. This is important for some teachers. Where are we? Here we go. So this is the cartoon that Landmark Cases recommends analyzing. You can see there are a lot of questions about it, but evaluating the message in here, it's pretty clear. The executive branch is weaker, has fewer players. The Congress is much mightier and bigger. And then we have the puny judicial referees in the background. So lots to chew on with that cartoon. Then, wait, sorry. Yes. Is the Judiciary Act of 1789 constitutional? This is, again, a little bit more sophisticated. This is, sorry, let me go into the, again, it prevents the background of the case. This is, again, Section 2 and 3 of the Constitution, but it also adds Article 5 about amending the Constitution. So these questions, which I'm going to just sort of scroll over slowly, really involve, the much deeper questions about how the Constitution is amended, and specifically, hypotheticals about the Judiciary Act of 1789. Sorry, my mouth isn't working. So this is actually, I think, a really, really wonderful resource that they put together here. And I'm going to show you one more thing, and then I'm going to talk about a couple of things. So then we have, for a more advanced class, something called the power of the judicial branch. And this is excerpts from the Federalist Papers, Federalist 78 and Anti-Federalist 78 and 79, that specifically pertain to the judicial branch and the organization of the judiciary. So very helpful. And then there are questions, again, conceptual questions about the Federalist Papers. I'm going to scroll a little slower so you can see it. Again, for more advanced students, more deeper thinking, wonderful presentation there. And then lastly, I think the last thing I'm going to talk about is, so I'm not going to show it to you, but they have a very interesting section on Thomas Jefferson. It's called Thomas Jefferson's Reaction Activity, and it's snippets from letters that Jefferson wrote to people with his verbatim words about how he felt about Marbury, how he felt about the judicial branch, how he felt about judicial review, and then also with Marshall, some of Marshall's words. And so you can compare Jefferson and Marshall there. And then the last thing I wanted to say is there is something about John Marshall's legacy, and that's a great exercise because it looks at all the other cases that Marshall decided or was involved in, and it's about federalism. And then we have the moot court activity, which I'll just end on, and that's United States versus Lopez, 1995, which is the, Tim, help me out there. It's the case where Congress, it's the gun-free zone case.
School zones case, yes.
Thank you.
Thomas Cloth case, yes.
Yes, which cites Marbury versus Madison. So it's a way of showing the case's relevance with a more contemporary decision. So I just gave you a quick overview of these wonderful lesson plans, curriculum guides, all kinds of things for teachers, which we highly recommend to go along with the documentary.
Thank you for that. Wonderful, wonderful. We've got some questions coming in and we're still taking more, but let me just mention some of the ones that we already have. There's a question as to whether or not there's a closed caption version in the works for teachers working with students with language-based learning challenges.
Yes, absolutely. And I don't know if we've already put it on YouTube yet. We're in the process of putting this on YouTube. And so you can also watch it without having to stop and start the sections. I don't know if everyone noticed, but I was pressing on each section after it was over. And that's a format that we find some teachers like, but the YouTube version, you can also run through it, and the YouTube version will have closed captioning. Absolutely.
Excellent, excellent. Another question. How does this work within the AP government framework? Do you happen to know the answer to that, Claire? I don't know.
I don't know. Maybe somebody from Landmark Cases could help out with that. I do want to say that we have a director of civics education coming on board at the society in 2 weeks, and she will be sort of taking over this kind of work for me, and has very much stronger classroom experience than I do. And I think I can shoot this question over to her and she can get back to you.
Excellent, excellent. I think at this point, Claire, we can probably stop sharing the screen, and like I said, we can open it up for questions and talk a little bit more broadly about not only the documentary, but lessons learned from it and from this very significant, even iconic sort of case, Marbury versus Madison. We do have a question from a teacher of constitutional law to first-year law students. And this is a question about the fact that the documentary didn't mention the fact that Marshall had been the Secretary of State, that he signed the commissions and had a potential conflict of interest here. Since that wasn't explicitly stated, was that a conscious sort of decision to leave that out of the documentary, or how was that dealt with as you were kind of working on this?
Yes, I mean, it's a fascinating question. Obviously, should Marshall have recused himself, and also the question of Marshall's brother's participation. So there's a lot of interesting ancillary questions about that. We were really, really hard pressed to get this down to 15 minutes, and we had to leave a bunch of stuff on the cutting room floor. So, but it's, it really begs the question, should there be specific curriculum materials that are targeted to those kinds of questions? I don't know, Tim, when you teach Marbury, or if you teach Marbury, how do you handle that?
Well, right. So that question does come up when I teach Marbury, and it's an interesting one in that, of course, we know the evolution of the idea of what is the appropriate role for a justice of the Supreme Court. And really, it's more of a 20th century notion that a justice would actually recuse himself from a case. And I even point out that there's another case, Martin versus Hunter's Lessee, that the Marshall Court heard in various iterations over a period of several years, where Marshall had some interest in some of those properties that were actually part of that case. He did not actually recuse himself from any of those instances either. So it's an interesting question, but I think it's more of a matter of evolving standards over a period of time. And of course, there is much more of a sort of fluidity when it comes to people moving in and out of the political world and the sort of judicial world in the late 18th and early 19th century. In fact, I'll just plug an article that's coming out in the next issue of our journal by Rachel Sheldon that talks about the fact that, in the early 19th century, there are justices of the Supreme Court who were trying to run for president while they're actually sitting on the bench. So some of the things now that we say would never be sort of permissible for justices of the U.S. Supreme Court, those weren't necessarily the norms or the rules yet back in the early 19th century. And I think that's certainly true in this case. We can take more questions. We do have a few minutes left, but maybe Claire, you and I could take just a few minutes to think about the significance of this case. I mean, it is interesting that the society had not made any documentaries about any other landmark cases, and you chose to focus on sort of Marbury, as opposed to another case. Is it the most important case in American constitutional history? What do you think? And if so, why?
It did make the judiciary branch stronger. And in terms of checks and balances, having it not be the weakest branch anymore. And Marshall really used this decision to do that, to accomplish that. I mean, there's two elements here. One is judicial review, but the other is just he managed to somehow bring up the power of the Supreme Court by losing the battle. It's when he won the war and he sort of gave up a small battle, and he didn't really tip off Congress or the president to realize what he was doing. But what he was doing was making the three branches equal. And without checks and balances, where are we? So yeah, it is the most important case, Tim.
Absolutely. Absolutely. And I mean, I would just add to that. And I think that what we've just seen kind of brings out this point. That Marbury really shows Marshall's brilliance, not only as a sort of jurist, but as someone who could navigate the world of politics and understood that the U.S. Supreme Court existed within that world. And that meant that he could sort of say that Marbury had a right here, but the court didn't have the power to offer him any legal remedy, and yet at the same time empowers the Supreme Court in this long-term way by establishing the idea of judicial review. And of course, the irony is that it was actually later in a case like McCullough versus Maryland, where the Supreme Court upheld the power of Congress, that we really saw the significance of judicial review. Really interesting if we think about how this case fits with other Marshall Court landmark decisions that, of course, went on into the 18 teens and into the 1820s. Mm-hmm. Well, I think we're about ready to wrap up. We don't have any other questions, but I do want to thank all of you who have tuned in here today. And just want to leave you with a few websites to know. Of course, that's supremecourthistory.org is the Society's website, and it is where anyone can access the documentary. Is that right, Claire? Mm-hmm. And also, excellent. And also landmarkcases.org, which you were showing us earlier, is where folks can find all of those resources that you shared previously. You will be getting a survey if you were part of our webinar here today. So you'll be getting a survey. We hope that you'll send that back to us. And we hope that there will be other documentaries down the road. Are there any plans for the Society to make any other documentaries, or is this kind of one by one, we'll sort of see what might happen next?
I don't know. Do you have any good ideas, Tim? What would you look for?
It is a great question that maybe folks could, if they do have ideas and as they're filling out surveys, they might indicate that, if they would want the Society to make another documentary on a landmark case, what would it be? There are certainly many others out there that would be candidates. Dred Scott, Lochner versus New York, Brown versus Ford, Roe versus Wade. There are many that we can certainly talk about, but we're really glad that we have this documentary. It's accessible, it's brief, it tells this rich background story in a very interesting way, and we think it'll be really useful for all of those out there who teach the history of the Constitution, the history of American government, and certainly the history of the Supreme Court. Anything else you wanted to add, Claire?
No, just again, my thanks to everybody who funded, participated, encouraged this happening, and especially to the teachers. My thanks to them.
Thank you so much, and thanks to all of us who watched. And as I said, SupremeCourtHistory.org is the Society's website, and we hope that you'll visit that. Thank you again.